The first matter before the court is Kennebec 23-393, Patrick Gordon versus the Maine Commission on Public Defense Services. It's my understanding that Mr. Gordon has decided to represent himself in this oral argument rather than have Mr. Parody argue. We have permitted that because he can represent himself. And I understand otherwise. Council are ready to proceed. We are being streamed live on the web, both by video and by audio these days. And if you're ready, well, first I would ask council and parties to identify yourselves for the record, saying your name and the party you represent, although Mr. Gordon, I know you're representing yourself, but if you would say your name out loud.
Yes, Patrick Gordon.
Thank you.
Megan Hudson-MacRae, representing the Maine Commission on Public Defense Services, formerly the Maine Commission on Indigent Legal Services.
Thank you. And Mr. Gordon, if you're all ready to proceed, we'd be happy to hear your arguments.
Good morning, and thank you very much for entertaining this appeal. First, I wanted to say that I'm not quite certain what this Assistant Attorney General is doing here. She was removed from this case due to a conflict of interest back in September of 2021 by Roger Cates, who was assigned by the Commission to hear my hearing. That followed, it happened contemporaneous with your Narowitz opinion, talking about the conflict when an AG represents and also advises. So I don't understand why she's here, but that being said, I'm objecting to her having anything to do with this proceeding here today because she was previously removed. To call what I went through, this process, a kangaroo court, quite frankly, would be an insult to kangaroos. The hearing that I had didn't rise to the level of wallaby, for crying out loud. But most importantly, one thing that hasn't been addressed is at all times during this proceeding, I worked for Fairfield & Associates. I was not a partner, I was not an owner, I was an employee. When I generated documents, I generated them on iPads, laptops, phones that were owned by Fairfield & Associates. That property that I generated while I was employed there is property of Fairfield & Associates. 17A 353 is very clear. A person is guilty of theft if the person obtains or exercises unauthorized control over the property of another with the intent to deprive the other person of the property. Property of another includes property in which any person or government other than the actor has an interest that the actor is not privileged to infringe, regardless of the fact the actor also has an interest in the property. I do not know, and no one has been able to tell me, how I could remove files that belong to Fairfield & Associates and turn them over to the Commission without committing theft. Further, I also reached out when this happened to the Board of Overseers and asked them if I'd be violating the bar rules if I turned over confidential client information to the Commission. I spoke with Aria E. personally, and she told me I was right. I couldn't do that. They go on to talk about my compliance and how I didn't comply. But what is clear is I did comply. I answered every question he asked of me. I answered them truthfully. I answered them in the detail that I could provide, that I remembered this is a case from some time ago. And the unfortunate thing is, he didn't like the answers Justin Andrus did, the interim executive director. I can't change the answers, and I can't change whether or not he likes them. The answers are the answers. And in regard to the documentation, he had all the documentation that he wanted. If you hear the transcript from the hearing, he had all the documentation. He'd received all the documentation, all the files from a post-conviction attorney that was working on a post-conviction that I was involved in. And it's clear that he had everything. So there was no way I could do any more for him than what I did.
Did you ask your former employer for all these documents? Say, I'd have urgent need for these. Can I have them? And they said no?
I was still employed there. I'm still of counsel. Yes, I asked my boss, Amy Fairfield. She said, no, we're not providing them. The reason being
Was that communicated to Mr. Andrews? That
It was.
Excuse me, that the employer said you can't have the documents as opposed to you weren't going to turn them over?
It was communicated that I was not allowed to turn
Okay,
them
is that
over.
part of the record?
It's part of the record on the underneath, yes.
Okay, can you point that to me? Because I didn't see that.
It's in our discussions that I had with Justin Andrus. It's in my letter to Justin Andrus that I was not able to provide that from my firm.
I understand you raised the issue of attorney-client privilege and some other matters. I want to be clear. Did you specifically, in writing, as part of the record below, raise the issue that you did not have access to those records and
Yes.
therefore could not turn them over?
Yes, I did.
And you can't point that out to me in the record?
It was in a letter that I wrote to Attorney Andrus, in one of my responses to him. I specifically wrote that in there, that I could not provide that.
Did you offer to provide a release to Andrus and to the commission so that they could pursue this without you being an obstacle between them and the documents?
I don't know what a release would have done.
But you refused to do one in any event. I mean,
I
they
didn't do
made
a release, correct. I don't know that I don't know that I can release something that's not mine. I don't understand how that could be possible.
Well, you were you were the point of resistance between what the commission was trying to get. You were saying, no, I can't do this. A release would have given them the opportunity to go to your employer, perhaps by subpoena, perhaps by separate matter, but you were the obstacle between them and the documents.
I was not the obstacle.
But you're the one who said no, you wouldn't turn this stuff over.
Correct. I said no because I couldn't turn it over. Right. And what you're interesting that you brought up, he had the power to subpoena documents for this hearing. He had that power, and he subpoenaed nothing. So, which begs the question, if you don't actually subpoena it, you probably didn't even really want it to begin with. So he represented by the AG's office, had the power to subpoena for that hearing. And he didn't
You
do
also,
that.
at one point, the record suggests that the commission was amenable to having all personal identification redacted from the document, all the rest of it to basically to de-identify it, to avoid any particular ramifications for the person there. But again, you were not agreeable to providing or giving access to redacted documents.
I wasn't, and the reason being is that I represented one client. Redacting that client's name from the record isn't going to give him any type of confidentiality, because you're going to know the name that's been redacted. I only had one client. So redacting his name would not protect his confidentiality.
So what you're saying then is a matter of law that the commission can never obtain an attorney's records for representation offered under the commission's auspices.
Well, as things are currently constructed, I think it's difficult. I do note that in the hearing, Justin Andrus talks about how he thinks the board, he thinks he's allowed to do that. But interestingly, in September of 2021, he asked the Board of Overseers that very question. He wrote them a memo asking, where he said, asking the board their opinion, he said, I anticipate that MCILS will request legislation that directly requires the disclosure of some client confidential information in the course of our investigative function. So he knew at that time he couldn't do it, and he was asking the board about that very issue.
Are your billing records subject to attorney-client privilege?
Yeah, I'd say yes.
Why?
Because our billing records specifically discuss what I did for the client.
Well, dates and times,
Sure.
and that's protected by attorney-client?
Yes.
Do you have any authority for that?
Just the attorney-client privilege.
Don't those records go to MCLIS or the commission?
They do not. So what happens is, at our firm, we have our program where I enter my billing time. So I enter all my time into our program. At that point, a staff member at my office would take it and enter it into the MCILS billing. So it's different than what goes to the commission. So I never, during this time period, I never sent a bill to the commission. I entered it in our internal timekeeping function of our office, and then our staff would in turn put that into a bill. So, and interestingly enough, we were investigated by the commission and by the Board of Overseers for our billing practice at Fairfield & Associates, and we were found to have no violations. And that was during the time period when this case was being requested from. So we had already been fully investigated by both the board and the commission. And in the hearing, Justin Andrus keeps saying things like, oh, we never investigated him. Just wrong. The commission did investigate us. They had done it fully, completely with the board. It was over several years.
Did the commission during that investigation get access to the billing records?
They did.
Why can't they have it now from you?
I can't give it to them.
You're telling us they already got it one time.
They did.
So there goes the attorney-client privilege.
With the consent of Attorney Fairfield. And it was being done by the board as well. So which is different than the commission, in my opinion. So
I just want to return to one thing. The letter that you say that you wrote to Justin Andrus with respect to your inability or Fairfield's reluctance to turn over the records that were sought. Again, I did not see it as part of this record, and that's what I'm just trying to establish. And do you have a reason as to why that's not part of this record?
I have no idea why it would not be part of this record.
Well, did you present it yourself to at the hearing, at the time of the evidentiary hearing, to be part of the record?
Yes, it was there. My responses to Justin Andrus were part of the record at the evidentiary hearing. And there should be a letter in there that specifically says, I'm not allowed to provide this documentation. It's in one of my letters that I wrote to Justin Andrus in response, was that I could not provide the property that he wanted.
Do you know the date of the letter? I mean, I think we all are interested in seeing that letter, and you just need to point it to us.
Okay. It would have been I wrote numerous things to Justin Andrus during this time period through both emails and in a formal written letter. It would have been, I believe, one of my last responses, or possibly when I filed for this appeal to ask for the commission hearing, it might have been in there as well. But I brought it up on numerous occasions that I didn't have the authority to do that.
And my understanding is you did not yourself testify at the hearing. Is
That's
that
correct. So at the hearing, one of the things we're talking about is the process here. So we, as I said, he had the ability to subpoena what he wanted to subpoena. He subpoenaed no documents from the firm. He could have done that. He chose not to. We were not allowed to subpoena who we wanted to subpoena, and which makes it very interesting how it could be a fair hearing if my subpoenas had to be approved by the Attorney General's office, the party on the other side of the hearing, and they refused to allow us to subpoena who we wanted to subpoena.
And is it part of the record that you were unable to subpoena somebody and what that person would have or should have been able to testify to?
It's part of the record that we are unable to, that he refused our subpoenas, correct. He said it wasn't, we wanted to subpoena the other commissioners.
But in part of error is, and if I had been able to, X would have happened.
Correct. So if I had been able to, and I don't think we actually got to that, 'cause I don't think he asked. He basically said subpoenaing the commissioners was not relevant. And then the first witness called by the state was a commissioner.
Okay.
So if one commissioner was relevant, they'd all be relevant. And so I fail to see how they can say it wasn't relevant when they themselves called one of the commissioners to testify. And I wanted to call the other commissioners as well, because what was important about that is the process that we go through. I had questioned his authority to do what he was doing. And much like if an unmarked car shows up at your house with an officer, someone claiming to be an officer in plain clothes walks in and says, hey, you need to give me all your property, you're going to say, well, I want to see the warrant. I want to know you have the authority to do it, and I want to know what the basis is. Throughout this whole time, he refused to give me his authority, and he refused to tell me the basis of the investigation. So I had no idea till literally they provided documents to us a week before the hearing was scheduled. It was the first time. This process was akin to a Russian troika. It wasn't a fair proceeding. I couldn't subpoena witnesses. I couldn't do any of the things that I wanted to do for this hearing.
Okay. Thank you, counsel.
Good morning. May it please the court. The Commission respectfully requests that this court affirm its order affirming the decision to suspend Attorney Gordon's eligibility to accept cases to represent indigent people until he complies with the Commission's investigation. As a preliminary matter, Attorney Gordon has failed to preserve any legal arguments before this court. The Superior Court's review in an ADC appeal would be merely perfunctory if an individual aggrieved by a final agency action was not required to both raise an issue before the administrative body and the subsequently reviewing Superior Court. As a matter of judicial economy, this requirement ensures that issues have an opportunity to be addressed and potentially corrected, and that there is a complete record before any appeal is taken to this court. Should this court consider the issues raised in Attorney Gordon's brief, the Commission's order should be affirmed. The order is supported by substantial, competent evidence in the record. Its procedures were fair, and it did not exceed the bounds of reasonable choices available to it. Briefly, to touch on Attorney Gordon's objection to my participation in this, he cites the Narrowitz decision from this court. That was in reference to 5 MRS 9055, which relates to adjudicatory proceedings in front of the administrative body. I was indeed removed from participation in that, actually by the presiding officer, moments before the Narrowitz decision came down, reinforcing that that was indeed the appropriate decision to make. I had no further involvement in front of the Commission. That decision and the Administrative Procedure Act is not relevant to an appeal taken pursuant to ADC and appearance before this court. Again, the Commission respectfully requests that you affirm its order, and I'm happy to take any questions.
And the Narrowitz decision applied to a circumstance because you were counsel to that particular administrative body that you had to be taken out, but obviously you don't serve in a similar role with this court.
That is correct. I am the Assistant Attorney General that is regularly assigned to provide legal advice to the Commission, and had been tasked with representing the Executive Director, as the Attorney General's office by statute represents agencies in matters.
Is the brief that was filed in the Superior Court, it really is just a recitation of facts. It's a brilliant opening or closing, but is that broad enough that we could perceive that or interpret that as being a challenge for arbitrary or capricious, just the recitation of facts contained in that brief?
I do not believe that it is. Again, that the ADC brief was an almost verbatim copy of the closing arguments, the written closing arguments that were submitted to the Commission. The issue raised by Attorney Gordon in that brief was as to the Executive Director's conclusions. The final agency action that was being reviewed by the Superior Court was that of the Commission. Attorney Gordon failed to appreciate that both the presiding officer who oversaw the adjudicatory hearing and then the Commission as a whole both reviewed his actions and interacting.
But isn't the argument essentially with the facts and that the decision was arbitrary and capricious, isn't that essentially a sufficiency of the evidence argument? In other words, that this decision is not sustainable for that reason?
That was the approach taken by the Superior Court. That was how they interpreted the ADC brief.
Would you address that, arbitrary and capricious, please?
The Commission did not exceed the bounds of reasonable choices available to it. The Commission has promulgated rules, Chapter 201, that outlines 2 different options for individuals who are aggrieved by decisions of the Executive Director, either an expedited process that's just on the papers or a full adjudicatory hearing citing to the Administrative Procedure Act. Attorney Gordon availed himself of that. Presiding officer issues a recommended decision, as he did in this case. The Commission thoroughly reviewed that decision.
Well, did he raise the issue below that he was unable to comply with the document request? I mean, isn't that a defense, if you will, to?
Attorney Gordon certainly raised that he was unable to provide those. I'm unaware of any portion of the administrative record where the reason for his inability to provide that was because his employer was saying that he could not provide that. Attorney Gordon certainly raised that he believed that the rules of professional conduct and attorney-client privilege precluded him from providing that.
Was there any legal reason why the Commission or the interim Executive Director could not have subpoenaed the documents from the firm instead of trying to go through Mr. Gordon?
Well, the commission does not have independent subpoena authority, investigative subpoena authority. It certainly had subpoena authority under 5 MRS 9060, but the only issue for that adjudicatory hearing was Attorney Gordon's compliance with the investigation. So arguably that would not have been sufficiently related to a fact at issue as far as actually obtaining those documents. The issue for the hearing was
Your
whether or not—
position is that regardless of whether you were able to or tried to obtain the documents in some other fashion, he still didn't comply with the rules because he didn't cooperate by producing the
Yes, Your Honor.
records.
Yes, Your
All
Honor.
right.
Now, three of the four questions that the interim executive director asked Mr. Gordon in February of 2021 were requests for information and not records. Was there ever any response to those three questions?
Yes, there certainly were responses, and there were follow-up responses to those questions.
Okay, so the only area that Mr. Gordon did not comply with is the furnishing of records?
The furnishing of records, there was a request for a release of any interest that Attorney Gordon may have held in his former client's file that would have allowed Executive Director Andrus to pursue obtaining those independent of Attorney Gordon. And there was some question as to the accuracy of the dates with which the Attorney Gordon had met with his client.
But did the commission believe that he had fully complied with the questions as opposed to the document requests?
Yes, the commission, when reviewing the recommendation from the presiding officer, did actually credit and amend that recommended decision to acknowledge that Attorney Gordon had provided responses to those questions. While they may have been
Sufficient responses?
yes, they had provided responses to those questions.
Well, paragraph 11B of the presiding officer's decision, page 13 of the appendix says, and I quote, "Contrary to Gordon's assertion, he has not satisfactorily answered all of Andrew's questions. He's never offered an explanation of why he billed a bench trial as a jury trial, indicated whether work performed by paralegals was billed to the commission as attorney time, never provided a complete list of the dates of meetings with his former client." Did he not comply, or did he?
So that's actually not the final agency action. The commission actually amended that recommended decision. So it adopted that with modifications. And again, those modifications were to credit that he did in fact provide answers. A question about whether or not those were reasonable answers, but certainly did provide answers to those questions. So yes, the presiding officer made those findings. The commission, when reviewing that and adopting—
Well, I'm really trying to understand this because I'm looking at the order adopting the presiding order's recommended decision, and that's at page 15 of the appendix, and it says that they find that he did order some explanation as to why he billed a bench trial as a jury trial, and there was that modification. I wasn't clear that there was additional modification of some explanation as to whether work, okay.
So those were the modifications.
Yeah.
And again, upon review, it's whether there's sufficient competent evidence to support the commission's finding that he did not comply. I certainly believe the failure to provide documents is that sufficient evidence to support their finding that he did not
So
comply.
I read that as still finding some fault with the answers, but maybe you don't say that, so that's fine.
There was certainly some concern about the adequacy of those answers. I would not dispute that there were answers provided to those questions.
Can I take you to paragraph 11A of the recommendation from the hearing officer? And there it says, "No documents have been produced despite the fact that both Gordon and his counsel acknowledged having possession of relevant documents." What did they acknowledge having?
So Attorney Gordon, in his responses to the inquiry, did acknowledge reviewing, quote, billing and other documents in providing that explanation.
Well, just to pick up, you said reviewing.
Yes.
The comment here is had possession of, so there may be a distinction there, and that's what I'm trying to get at.
So the executive director testified, actually referenced Board of Overseers ethics opinion 219, that an attorney has an interest in their former client's files, even if they're not the attorney that is ultimately retaining those files. That was the reason for the request for the release, to the extent that there were documents that he was unable to provide copies of. And again, it was for copies of these documents. There was no request for the originals of these
Did
documents.
Mr. Gordon assert that he could not just, not for ethical reasons, but that he could not access the documents, and that is the reason for not producing them?
The only evidence in the record that I'm aware of where Attorney Gordon had articulated an inability to access a document was what is referred to as the voucher, which is actually a voucher report that is generated after attorneys submit their time into the system used by the commission. And that was a misunderstanding that Attorney Andrus subsequently recognized that through a series of an attorney leaving the firm that he did not have access to that. But Attorney Andrus did testify that the failure to produce that record was not the basis.
Wasn't
for
there
his decision.
some suggestion that the file simply had disappeared and no one could put their hands on it?
There was both a representation that there had been, everyone in the firm had looked for the file, and that the firm had retained every file ever created since its inception.
Was Mr. Gordon prevented from presenting witnesses or evidence at the hearing?
No, absolutely not.
He indicated that he was not allowed to subpoena any witnesses.
I believe that is a misstatement, that because the commission did not have independent subpoena authority, it was required to go through the Office of the Attorney General to request subpoenas. Both the Assistant Attorney General, who was representing the Executive Director, and Attorney Gordon first made the request to the presiding officer, which was required by rule, who authorized the subpoenas for both parties. Those requests were then sent to wholly separate Assistant Attorney General, who responded that he was unable to see how those subpoenas related to a fact in dispute, and it seemed to be a legal issue.
They were requests to subpoena commission members?
All of the sitting commission members.
Okay.
And that it appeared, based on the information that was presented, that it was a legal issue, and the request was to provide additional documentation or additional briefing to support the argument that that was related to a fact at issue. After that, the presiding officer reversed his previous assessment about the appropriateness and said that neither party should get those subpoenas. I'm unaware of either the Executive Director or Attorney Gordon following up and providing any supplemental briefing on necessity.
Is there a tension between the attorney-client privilege and the Commission's duty to investigate compliance with appropriate practices in defense?
I don't believe that there's a tension between the attorney-client privilege and the Commission's obligations to ensure that there's quality, competent representation in a fiscally responsible manner. That rule of professional conduct does have several carve-outs authorizing the disclosure of certain information. I would just note that certainly as it relates to billing information, the time, the date, the amount of time spent representing somebody, that's all information that is provided to the Commission anyway in order to receive payment. So that information, while certainly understanding the process employed.
Mr. Gordon seems to have a more expansive view of the attorney-client privilege. The tipping point really is you can't have any of this because the attorney-client privilege creates a bar to it.
Respectfully disagree with that assessment, and would state that it does seem that the legislature certainly contemplated the Commission having access to attorney-client information for MRS 1806, does reference and actually remove from what would otherwise be public records information in the Commission's possession that is protected by the attorney-client privilege.
There have been reference made to a prior investigation of Fairfield and Associates by the Commission. I'm assuming there's some, institutional knowledge as to how you went about getting information at that point in time. Was that ever explored in this context?
There's no evidence in the record about that, and again, the Commission was, to the extent that there were any other investigations, the Commission was unable to assess whether or not that would have been duplicative because Attorney Gordon refused to produce any documents that would have allowed that analysis.
Thank you.
Thank you.
Mr. Gordon, you reserved 2 minutes for rebuttal.
Yes, I could direct the court, please, to what is in the record as pages, I believe, 142 and 143. That was a letter that I wrote in response in, I believe, July 21st, 2021. It's again, the part I'm referring to is at 143. It says, I am an employee of Fairfield & Associates. As such, every written thing I produce while working for the firm is property of the firm. Consequently, the documentation requested by Andrus is property of Fairfield & Associates and not mine to give. Further, I did not have access to the submitted MCILS bill in this matter, and Andrus would not even provide me with a copy of the bill. So yes, it is there clearly in the record that I said that previously, and it's all part of the record here. I've been saying it all along. I can't give you something that's not mine. I can't take from the firm and give it to someone else if it's not my property to give. And to say that I could do that, A, at a minimum I'd be fired. B, it would certainly violate the bar rules. C, I could be charged with theft. Finally, I offered on numerous occasions to sit down and meet with Justin Andrus so I could tell him everything that I knew. Because I said, I can't give you documents, but I can sit down and meet with you. He refused. He refused when I did it initially. He refused again a second time when Attorney Parody and I offered again. At the hearing, he said he couldn't.
If you sat down with him, would you waive the attorney-client privilege and talk about dates and times and things you experienced with your client?
I could talk with him about certain things, yes. I couldn't give him the documents, though. They're not mine to give.
Did you actually ever ask your employer if you were authorized to turn over the records?
I did, yes, and she said no. She was also suspended at the time.
Any explanation for that?
Said we've already been through this. We've already gone through a full commission investigation. We've already gone through a Board of Overseers investigation. We're not going to do it again.
And did you supply that, did you pass that along to Andrus? Because I hear you saying that the documents were not yours to give.
Correct.
But did you ever follow up and let him know that you had specifically asked for the documents?
From my employer?
Yes.
Aside from, I know that came up in the course of the discussion, but this is where it's concretely in writing, where I say I'm an employee of Fairfield & Associates. As such, everything I produce while working for the firm is property of the firm. But he didn't want to sit down and meet with me.
Thank you, counsel. I see your time is up. As is our usual practice, we will take this matter under advisement, issue a written decision in due course. It's also my understanding, Attorney Hudson-MacRae, that this is your first argument in front of this court. And as is our usual custom, we'd be happy to have you and counsel come back and take the greetings of the court.